Hi, I'm Bea Cupin. You're watching Rappler. We're joined by Attorney Ted Te and Maria Ressa. I will just be giving a few updates because there are developments or updates on the libel case filed against Wilfredo Gang. So maybe Maria and Attorney Te, you can just walk us through what happened yesterday and what happened this morning at the Makati City Hall.
Okay, should I go first? Yeah,
Go
maybe I'll
ahead.
go first. Yeah, thank you, Bea. Well, today we submitted the counter affidavit of Maria in the Makati City Prosecutor's Office in connection with a second complaint for cyber libel filed by Mr. Keng against her. This time arising out of a tweet that Maria posted on February 16. Uh, and we submitted the counter affidavit today, but Maria had subscribed to her affidavit yesterday earlier because of a conflict of schedule, which we had cleared already with the prosecutor. So the prosecutor allowed her to subscribe to her counter affidavit a day ahead because she couldn't make it this morning. So what happened this morning was we submitted her counter affidavit to the prosecutor, and as far as the prosecutor is concerned, he has considered the matter submitted for resolution. So that means that we are now waiting for the prosecutor to resolve the complaint filed by Mr. Keng for cyber libel.
On my end, this whole I guess the first is it just doesn't stop. June 15th was the verdict on the first cyber libel case, and then we've in that one, Ted and I again, we filed a motion for partial reconsideration. The Mr. King's side was given a chance to respond to it. Judge Montesa and RTC Branch 46 ruled against this, and that case has now been pushed up to the Court of Appeals, which is where we're taking it. Right. This case is a second one, as Ted said. I received a letter asking me to take down a tweet. And so this definitely falls under this, at least they use the cyber libel law again. A tweet that I tweeted in February last year, February 2019. And the letter that I received from the legal firm said, take it down and publicly apologize. This was a tweet of the Philippine Star article from 2002. I didn't write anything new except to say this is the background of it, and then the article was written by the Philippine Star. So I felt like I couldn't really. This is all the stuff that I had put into my response. So I suppose if I was prudent, I wouldn't have. I would have taken down the tweet, but I also felt like this is part of holding the line, that you don't allow any kind of intimidation, and so this is where we are again. Thank you, Ted, for representing me again. And I guess that's it. It just doesn't stop. We've had several few years of this, and it's important that we keep holding the line.
Okay, I think we'll bring in a couple of reporters. They have questions. We'll cue in Mike and Dion.
Right.
So I think
Ian?
Mike can go first.
Yeah,
All
I
right.
can go first.
Sir Ted, good afternoon. Ma'am Maria, good afternoon.
Hi, Mike.
I just want to ask, how did the other side try to argue, and what is your argument against that this particular tweet of Maria can be considered a new form of a tweet, a new form of post to make it liable under cyber libel? Because in the Dicini ruling, it was made clear that if you just share or if you just like a post, then it's not covered by cyber libel. So what's the argument and what's the counter argument to that?
Well, that's the strange thing, Mike. No, the complaint itself, filed by Mr. Ken, basically ignores the jurisprudence on the matter because it just simply straight out says that Maria tweeted this item and defamatory. This violates the law, etc., etc. And so our the counter affidavit that Maria submitted basically refutes that as a matter of fact and as a matter of law, meaning the 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 only words that Maria wrote on that tweet are not defamatory in any by any stretch of the imagination. No? The tweet reads, quote, here's the 2002 article on the, quote, private complainant, a private businessman, unquote, who filed the cyber libel case, which was thrown out by the NBI, then revived by the DOJ. Hashtag hold the line, unquote. That's the tweet itself. And then of course the tweet then shared the article, the 2002 article on the Philippine Star, reporting on another matter altogether. And so, in the counter affidavit, Maria pointed out that the prevailing state of the law on cyber libel is still the CINI versus executive secretary. And in that case, the court said specifically that if you share something on social media, meaning you did not write what you shared, then you cannot be liable. Only the author can be liable. So again, it's a matter of fact, meaning the whatever Maria wrote is certainly not defamatory. And assuming without agreeing that the content that was shared was defamatory, under the law, it's still not cyber libel because the CNE says you can't be charged with cyber libel if you didn't write what was shared. And so,
Mhm.
we're hoping that the prosecutor will see that that is really what the law says at the moment, right? And at face value, it doesn't look like there's a prima facie case for cyber libel. And so, but there's also another aspect to this case because again, it's not just Maria, right? We did point out that many other people shared that article. Many other people shared Maria's posts, and so if this complaint is resolved adversely against Maria, meaning she gets another cyber libel in charge as a result of this, then it's really dangerous for anyone now on social media who shares anything whatsoever. And so basically, that would be a reversal of the CNE, and so that's where the danger comes in.
Maria, did you, for just I don't know 1 second, consider deleting the tweet and publicly apologizing?
A second. I mean, it would be foolish not to think about it given the number of cases we at Rappler are facing and the number of cases I'm personally facing, right? But at the same time, it's the reason why we continue fighting back because if I give in, look, what have we seen? We've seen students subpoenaed, we've seen people arrested for social media posts. I just felt like I am strong enough. This is yet another attempt to intimidate, harass. We have to show up in at the prosecutor's office, and if I gave in to it, then it's a victory, right? I think that I've been talking about death by 1,000 cuts. If you just allow yourself to bleed out, you will die. And so for me, it's this. Sorry, I also say we hold the line. Imagine if I said, well, this is only a really, really small thing, and maybe I'll just step back just a little bit. And then I stepped back 1,000 times and 1,000,000 times, and I've just lost all my rights. So I think it's incumbent on me as a Filipino citizen and as a journalist to hold the line. People should not get away with intimidating others or pounding others to silence. It's just not right.
Attorney Ted, ano lang, question lang, why was it filed in Makati? What's the explanation for that? When the other is in Manila.
Oh, yeah. Should I get that? Why was it filed in Makati, not in Manila? Well, the choice is to the complainants. Under the law, we follow the libel law follows the first publication rule, meaning if the principle is that when something that is defamatory is published, uh, the the person who reads it, the first time, can say, I read it in Makati, and therefore that is where the offense was committed. So first publication. So basically, what they're saying is that this particular tweet was first read in Makati, and therefore they filed it in Makati. Regarding the first cyber libel case, well, they were basically saying they first read that in Manila, and therefore that's why they filed it in Manila. That's a principle that's found in libel law.
Okay, thank you.
Okay, sir. Just going back to Sir Ted, I just want
Mm.
to ask: would it make a difference when King, for instance, would argue that the Philippine Star has already deleted that particular article, and yet Maria retweeted it by sharing a screenshot? Can they make a case that that's a new post altogether?
Uh, no, because I think as far as the Philippine Star was concerned, the reason they deleted it was, well, because they were basically threatened with suit, right? And that's stated in the affidavit, and it's still out there. Well, you guys would know this better than me, but once something is written in the internet, it's out there. It
Mm.
exists forever, basically, and so there's no half life for that. So it is out there, and people, it is still accessible, and we mentioned that in the counter affidavit that it is still accessible. And so it's not as if it was specifically dug up and then retweeted. No, it is available, and but the explanation of the Philippine Star itself leaves room for a view that says what we reported in this matter is actually true and correct, and we stand by it. Except that, well, we want to avoid being sued, and that's why we're taking it down. And so, it is a matter of public information. It's a matter, I think, for a journalist or even an ordinary citizen to let people know what's going on. And so, again, we go back to that principle, right? If you post something and it's a matter of information, can you be sued for libel simply because you shared something? Uh, I think the Decini rule would cover that. But yeah, but to answer directly your question, uh, they can probably argue that. They can probably argue that, but the item has not disappeared. It's still there. It's still accessible.
Mm. Which
Related lang. Sorry, go, Mike. Go.
which begs the question, sir. I think you've been asked before about this. Why did they not ask for an injunction, probably an order from the court to take the particular article, wrap the article off the internet? They could have done that, right? In the Manila RTC, is that a possible remedy for them if they really wanted to, take this information off the internet?
You know, technically, yes. If we're speculating on what could have been done on their end, if they really wanted to address supposedly the defamatory, content, of the article, one remedy there is habeas data. Habeas data, has one of the remedies in habeas data is to repair, restore, and so it is available for them. I don't know. I can't speak
Oh, we lost.
for an injunction or why they didn't ask for habeas data to correct. No. So, but yeah, but I mean, as a matter of law, there are remedies to
Mm-mm.
to address that.
Mm-mm.
Sorry, just going back to Mike's question on republication. Kasi when Judge Montesa ruling came out, there were some comments na this would open up yung kunyari, old articles from the 90s, and then the newspaper digitizes the articles that could open up to suit kasi considered siyang republication. So isn't that can that be the same argument na tinake down na yung Philstar article but the screenshots parang revived it, so that's a republication? And substantial change siguro kasi like the entire article was posted again via screenshot.
Well, if you're talking republication as a legal concept, then republication would refer to to the same publication, putting it out again with substantial modification. And so it really does not refer to a situation where someone on social media shares it, because again, that was precisely the question that was addressed in the Decini case, wherein the court considered social media as the milieu under which the Cybercrime Protection Act was enacted. And because at the time it was, well, relatively new for the court, and so the court basically said, no, you can't be charged if you're not the author. You can't be charged if you simply share it. It's not cyber libel. So it stands to reason it's also not republication, because I would suppose that the principle of republication, based on at least the US cases, is that the same person who published it the first time republished it. In this case, well, it would have to be Philippine Star, right? And in this case as well, this was a tweet, not, it wasn't written in Rappler or anything. It was a tweet by Maria on her Twitter page, on her Twitter account. So yeah, I think it would be a stretch to say, to argue and to hold that it would be republication as we understand republication as a legal concept.
Okay, thank you.
Can I just
Nawala si
add?
Mike.
Yeah. I was going to take, because Mike talked about the rationale of why not ask for the article to get taken down. I think this is us trying to make sense of what people have said when the actions are actually also saying something. It's very hard to look at intent, right? And this is part of what the judge in all of our cases have to do. Um, the fact that if that this is a war of attrition, I guess is what I'm saying. That if this really wasn't an attack on press freedom, if this wasn't a specific targeting on me because I'm a journalist who speaks, who will hold the line, if I wasn't specifically targeted, then would all these cases ever have come about? You can rationalize every single case and come up with a plausible narrative, just like you can rationalize the shutdown of ABS-CBN. And to hear officials actually say, when the vote happened at the House, and Harry Roque, the press spokesman, the presidential spokesperson, said that the President Duterte had nothing to do with it, and yet you have multiple statements from President Duterte threatening this. I guess this is why we have to take what everyone says, including what we say, with a grain of salt, and look at the actions. And the actions prove intent. The actions prove a chilling effect. Forget chilling, we are in Siberia.
Okay.
Last lang,
Troy,
Attorney Ted, when do you expect to file, or when do you target to file the appeal at the Court of Appeals from dun sa Manila RTC ruling?
We filed the notice already, so we're simply waiting for the notice to file briefs. But we're also filing some motions for interim relief. For example, the request to travel on Dr. Maria. But notice has already been filed with the Court of Appeals.
mm-mm. So if I can just ask one more about the concept of public figure, I guess also for those who might not have read the pleadings and would want to understand the concept of public figure, those who are watching, how would you explain this, sir, in very simple terms? Because your argument is that Mr. King is in fact a public figure, and so therefore there's no presumption of malice. They have to prove that the article was maliciously written and published. But Judge Montesa was saying that he, during the cross-examination, it was shown that he was a public figure, he was a private citizen, and that they have in fact proven malice. How would you explain this in simple terms for those who may want to know more about the public figure issue?
Yeah, thanks. That's a very important distinction, no? In libel law, the public figure exception, because under our law, we have a very strange rule that basically reverses the burden of proof and puts the burden on the accused to prove absence of malice. And that's why many have argued that our libel laws are unconstitutional. In fact, just very quick digression, during the oral argument on the cybercrime protection law, Justice Carpio, in fact, mentioned it expressly from the bench, saying that so why don't you go all the way, not ask only for the cybercrime protection law and cyber libel to be declared unconstitutional, but ask that libel itself as a felony be declared unconstitutional, because position is that under the law, which reverses the burden of proof, that's unconstitutional. But right now, because the Philippines also adopted U.S. case law, no? In New York Times versus Sullivan, which established that, no, that if you are a public figure, if you're a public official rather, you have less expectation of privacy, and therefore you should be more open to criticism, and therefore in that case, there needs to be proof of actual malice, this time by the public officer. But in the Philippines, we've also expanded that doctrine to not only include public officers but also public figures. And a public figure, definition of a public figure is quite elastic. And I think this was explained in Ayer versus Capulong, involving former Senator Enrile, wherein even if a person is a private figure, no private person, but by some reason which he did not seek out, his name is involved in something that is relevant to the public interest, then he becomes a public figure. So in this situation, the story that was written in the first cyber level case, the one in Manila, involved a public figure, uh, and a public official at that, the former Chief Justice. It involved also a matter that was of the public interest, because it spoke of a possible connection between a private figure and a public official. And so under case law, Mr. King would fall under the principle of a public figure. And therefore, since he's a public figure, the burden is back where it belongs, on the part of the prosecution. And they have to prove actual malice rather than just relying on the presumption of malice and requiring the accused to prove absence of malice. So that's how it is. It's a very strange set of laws, because again, these are very old laws, and they really haven't been updated since things have changed.
Sorry, just to follow up to that, is the fact that Rappler did not issue a subsequent article correcting it or clarifying it, can that be taken as proof of malice? Is that the kind of malice that we're looking at under the law? Because that comes after the fact of publication.
Sorry, I didn't catch that.
The fact
Is
that Rappler did not issue a subsequent article clarifying or publishing the side of Mr. King after the story was published, is this the kind of malice that the law is contemplating? Can you say that this is malicious because they did not publish a subsequent article? That comes after the fact that the article was published. So can that be taken as proof that there's malice here?
Well, did not publish this, right? This was Maria. I mean, you're referring to this second case.
I was referring actually, sir, to the first one, sir. The first libel case.
Sorry?
I was referring to the first cyber libel case.
Okay. And the first cyber libel, that Rappler did not publish.
Supposedly, the proof that there was malice is that Rappler did not publish the side of King, did not issue any clarification,
okay.
Despite the fact that they reached out. Can that be taken as the malice that's contemplated under the law?
No, I don't. One, malice here would be similar because it's a felony. Malice here would have to be interpreted as criminal intent, meaning intent to defame the person, right? And so intent to defame the person has to be shown by actual acts, meaning that there was a knowledge that this was not true, or this was not accurate, and therefore, despite that, they published it. What Rappler did in the first cyber libel case was, Rappler published a, a a report, based on an intelligence report, and again quoting, and the second part quoting from a Philippine Star article again. And in both instances, the publications were referenced, meaning, it mentioned a report, it mentioned the Philippine Star. And so the basis was there. And the question as to, should Rappler, for example, have uh, determined that the confidential report was true and accurate before publishing it, right? And does that constitute malice that they did not do that? I don't think so. That Rappler did not ask uh, Mr. Keng for his side. Well, the information expressly says that Mr. Keng in fact was called up and he did reply, and so that part factually isn't accurate. And so, but it's I think it's pretty dangerous to say that, for the court, for example, to say that if a reporter fails to get the side of the other person, uh, for publishing, that by itself is malice. I think something more has to be added there, and what needs to be added there is criminal intent, meaning, that this was not just simply a lapse, this was not just simply the other side not not allowing the report to push through because he did not want to say anything on record, because those are implications on journalism, right? If the other side simply says, I don't want to say anything about that, would therefore that not mean that you cannot proceed with publishing it because the other side hasn't commented, right? And so malice here would have to be reckoned from criminal intent. Did the post criminally intend to defame this person? No, because if there is a good motive shown, and what is a good motive shown here? If the matter was a matter of public interest, it was public information that needed to be put out, then that is a defense against the proof of malice. So I think that's where we stand, and of course that's an issue in the cyber libel case, the first one in Manila, right? And therefore, that's of course one of the points that will be raised in the appeal when we file the case.
Right, sir. Thank you, sir.
Thanks, Mike.
Sir, ultimately, are you looking at the possibility that this could reach the Supreme Court and the court may have to revisit the libel laws and the cybercrime law again? And do you welcome the chance to scrutinize the cybercrime law and our libel laws once again?
For for Maria and Ray Santos's peace of mind, I hope we don't have to go to the Supreme Court, right? Because if we do have to go to the Supreme Court, that means that we would have lost the appeal in the Court of
Lost.
Appeals, right? As a lawyer, of course, I don't want to have to go to the Supreme Court to argue it again. But of course, that possibility is always there. Meaning, if the Court of Appeals, uh, you know, uh, denies the appeal, meaning, affirms the RTC decision, then of course, that option is there. We would have to exhaust all options, and including going up to the Supreme Court, for review, and of course, raising the question now of cyber libel, this time as a specific instance, right? This would be the CINI again, but this time more focused on cyber libel, and this time no longer a facial challenge, but this time an as applied challenge, because there is now a specific case where someone has now been charged with cyber libel and in fact convicted and now being reviewed. So yeah, I mean, I wouldn't want to, but we're prepared to go up if necessary.
Sir, are you seeing any hope that the
Okay, thank
recent,
you.
are you seeing any hope that the
Sorry,
recent
Mike.
sorry.
One last question from Mike.
Ted Filon was recently acquitted of libel in the Court of Appeals. Are you seeing a glimmer of hope in that? That decision, although focusing on libel, somehow discussed press freedom in the context of a government official.
yes, I agree. It's a glimmer of hope. And so yeah, I mean that's what I'm saying. Hopefully, right, in the Court of Appeals, we get to reverse our luck, and we manage to win one, right? And so again, there are a lot of decisions in the Court of Appeals. Yeah, it's a question, of course, of how the particular justice would appreciate the facts, the evidence that has been presented, the issues of law presented, and so yeah, I mean, right now the only thing we can do is write the best brief we can, the most convincing brief that we can, and hope that the Court of Appeals agrees with us. But yes, I mean the recent decision that was released by the Court of Appeals is, does give us a little, that's a little hope that it might be a take two, at least for this case for Maria and Ray.
Thank you.
Thanks.
Thank you, Attorney.
Thank you.
Thanks, Lian and Mike. Siguro to end today's stream, Maria,
I guess,
anything you want to
it's
say?
this, that it just doesn't stop, right? Every week there's something to do with the courts. Uh, this week there were two court hearings. Wednesday we had a hearing at the Court of Tax Appeals, right? CTA. So we had a hearing on tax. There are five tax evasion charges, and then there's today at this second one case. So that's a total of 8 criminal charges. I think Mike, you mentioned all of the details, and I think Ted answered really well in the first cyber libel case. But I think the kinds of legal acrobatics to bring us to this point where you have to shift, you have to ask about republication, what's the definition, you have to ask what is the period of prescription for libel, and that is now, if you just look at that one, it went from 1 year to 12 years to 15 years in the process of court. And I think this is the last thought I would love to leave you with, is that what we are seeing right now, I think, is the codification into law of the random abuses that have happened in the last 4 years. And I would include there how in democracy, our democracy right now, the very processes of democracy are being turned against it. And I would include there what's happened with our legislature, where we seem to have a captured legislature that is ready and willing. The shutdown of ABS-CBN, once unthinkable. I mean, of course, not since 1972. This has happened. And I don't think it's going to stop. ABS-CBN, the anti-terror law that we are all fighting, this is all part of that. The law is now, law and processes of democracy are being used to actually consolidate control. And that one I'll toss, because I know Ted will have the last word on this. Ted, we've learned a lot of lessons in the last few weeks from ABS-CBN, the vote on ABS, the actions against us, the anti-terror law, all of those petitions at the Supreme Court. What do you see ahead? What does this mean for us?
Yeah, well, maybe as a final words on this point, and just looking ahead, because again, these are cases that we have to take on, cyber libel, but there are bigger issues, and these bigger issues, I think, would implicate the court, judicial branch, the Supreme Court, particularly in its role of trying to be the neutral arbiter between two branches of government, the executive branch and the legislative branch. And so, it's a good time as any for the judiciary to basically to assert, that the people can still trust it to be a neutral arbiter, and that it is not, well, part of the capture, as it were. Of course, many people can do the math. They're saying that, of course, you also have a supermajority in the court as far as the justices who have been appointed by the current president is concerned. But again, the Supreme Court before has surprised people. I'll mention a case involving the state of emergency during the time of Gloria Arroyo, when Chief Justice Panganiban, who was appointed by Gloria Arroyo as Chief Justice, ruled against her in two successive cases, and these were big cases, for example. And so yes, it has that tradition, and right now, really because of the power flexing between the two branches, among the two branches, executive and Congress. It's really up to the courts, and the courts really have to step up. The Not only the Supreme Court, but even the courts, because the hope is that we don't have to push all the issues up to the Supreme Court, because again that will take time. So we're hoping that I mean I'm hoping as a lawyer that the judiciary really comes in and shows that can be counted on. And the test, I think, the litmus test would be the various petitions filed involving the anti-terror law, because I think we're up to 20 or 21 petitions, and from a very diverse set of petitioners, practically very representative of the population. And so it is a very good occasion for the court to respond, to show that it can still be relevant, it can still be counted on to be, again, a neutral arbiter involving these issues.
Thank you, Attorney Ted. Thank you, Maria. Thank you, Mike and
Thank
Lian, for
you.
dialing in.
Yeah.
And thank you for watching the
Thanks,
stream.
Bea.
You've been watching Rappler, where we continue to hold the line. Thank you, guys. Good afternoon.
Thank you.
Bye.
Thank you, Maria. Thank you, Sir Ted.
Thank you.
Thanks, Mike. Thanks, Leanne. Bye, Bea.